Okay. Hi everyone, we are live now. Okay. Good afternoon everyone. Welcome to Tea Time with JK and Co. So from today onwards until the 18th of July, we'll be having a series of talk on every Sunday 3 p.m. And today we'll be discussing on the topic about police arrest. So today we have another 4 speakers to share with us. Miss Wong En,
Hi.
Mr. Jason,
Hello.
and also Mr. Satya.
Hello, everyone.
And also myself. Okay, so because many of us actually still unclear on what to do if the police stop us, and what are the rights we have if we are arrested, and what we can do, and what can the police do to us if we are arrested. So today we are going to share about this. Okay, so because many of Okay, so for now, we are going to, before we start on arrest, let us look about stop first. So what are the rights we have if the police stop us? So when we are walking on the, for example, we are walking in public, suddenly the police stop us and they say they want something from us or they want to arrest us. But what can we actually do? Because not every person wearing a police uniform means that they have the authority to do so. So one of the things that we can do is to actually verify their authority card. In Malaysia, our police authority card, we have 4 different colors. First one is white color, means the police is the police reserve. The second one is yellow color. He's a police officer, but then the rank is below an inspector. The third one is blue color. His rank is above the inspector. But then you have to be careful if the police authority card is red color. If it's red color, which means that he is a suspended police officer, and basically means that he do not have any authority to do anything on you, or they cannot get any information from you. So if you see that their authority card is red in color, you can straight away walk away because they do not have any authority. So after we talk about stop, let us look at arrest. So normally when we talk about arrest, there are 2 types of arrest. So actually, which is actually arrest with warrant and also arrest without warrant. We have to know that warrant is basically means a writ or an order given to the police to actually say that the police has the authority to do something. So when we talk about arrest with or without warrant, we have to see a series of the offences under the Criminal Procedural Code. And inside for this first schedule, the 3rd column there, they will actually show us what kind of offense is they need warrant to arrest you and what kind of offense they do not need any warrant to arrest you. So normally for arrest with warrant, it is it's like less serious offense. For example, like defamation, forgery. If all this kind of situation, if the police wants to arrest you, they have to show you a warrant to say that you are arrested. But then if it is more serious offenses such as robbery or theft, or you enter others' house to steal their property, in all this situation, the police can straight away arrest you without warrant. So once you are arrested, you will actually be curious who arrest me, or can they use force to arrest me? So basically, for who can arrest, we understand that police or the penghulu or the magistrate, they actually normally have the authority or the power to do so. For example, we can see this in under section 23 of the Criminal Procedural Code. But what people are actually curious about is whether a private person, just like you and me, a normal person, can we arrest someone, or can all these private person arrest us in the public? Actually, they can. Based on section 27 of the Criminal Procedural Code, private person can actually arrest someone. But then, the offense must be a seizable offense, which is the arrest without warrant, for example, robbery or theft. And then this private person must see the person and also witness the person doing that crime. For example, today, you are walking on the road and then suddenly you saw someone go and rob the bank. They go and rob the bank and go and steal the properties. And then you caught him. And actually in this kind of situation, you are allowed to arrest the person. But then you have to straight away bring him to the nearest police officer or also the police station. Okay. And another question people ask is whether this police can use force or not. Police can actually only use a reasonable force if the person arrested actually resists lah. For example, they use force back they fight back. They say, okay, I don't want to follow you. Then they fight back with you, or they have the weapon and say, okay, I don't want to follow you back. You let me go, or this kind of thing. Then the police can use a reasonable force to actually arrest the person. But then if the arrested person himself already surrender or they follow the instruction, then the police cannot use any force to arrest this person. Okay. So now we will be always very curious when we are arrested, what are the rights we have? What can we do when we are detained? And what can the police do to us? If you are arrested without warrant, means the police didn't show you any warrant and they arrest you, you have to make sure that the police tell you why they arrest you. Means they have to let you know what crime what offense you did that makes them arrest you. Then before the police asks you anything if you are detained, you answer anything to the police, you have the right to call your friends or relative to tell them what happened to you. And at the same time, you can also call a legal practitioner, for example, a lawyer, and meet him and also to consult him to ask him what can I do and what should I do. So in this kind of situation, the police actually have to give you some time and also the legal practitioner, but the time must be reasonable for you all to discuss and also meet each other. Then after this, if the police ask you any questions, generally you have to answer all the questions and it must be true. But if today your answer might expose you to some criminal charges or also penalty, then you can choose to remain silent and also choose not to answer those questions. And another very important thing that all of us must remember is the police can only detain you for not more than 24 hours. And then if after 24 hours, they do not have any evidence to prove that you are actually guilty of this offense, then they have to release you. But then the police or the public prosecutor can always apply for remand order. Remand order is basically a right given by the magistrate to actually detain you for more than 24 hours. But in this kind of situation, the police have to give reasonable explanations to the magistrate and tell them why I need more than 24 hours, why I need to detain this person for more than 24 hours. So normally this police can apply for 2 times. And if the offense, the punishment of imprisonment is less than 14 years, the detention cannot be more than 4 days for the first application and not more than 3 days for the second application. So in total, you cannot be detained longer than 8 days. However, if the offense itself is more serious and the penalty, for example, it's death penalty or the imprisonment is more than 14 years, and then the most you can be detained is not longer than 15 days. So until when it reached these 15 days and the police still do not have any evidence to prove that you are guilty, the police have to release you no matter what. They also have to release you because it's more than 15 days already. Okay, so this is basically some laws about your rights and also this remand order. And Mr. Jason, we know that you actually deal with some criminal cases. So do you have any experience or can you share with us normally what an accused person will encounter when they are detained?
Yes. Yeah. Thanks, Natalie, for the sharing. As far as arrest until remand is concerned, in our practice, I have personally experienced on this part of area whereby any person who got arrested, of course, will have the rights to inform on what grounds that the person is being arrested. Right. I think Natalie have make it very clear that everyone will then be subject to police questioning, or we'll call it an investigation conducted by the investigation officer, or in short forms IO, simply because you are the suspect. All right. It doesn't mean that you are guilty of an offense because you have not charged to court yet. So at that stage, you are a suspect, and we normally the practitioner or the police will then use this term is called OIDS, which is very commonly used as orang yang disyaki. So at that stage, you will be then have to cooperate with the police. No issue. You just cooperate with them and conduct the interview sessions. So what the police will normally do will have to record your statement. Okay, record percakapan. All right. Then we call it sections 112 statement. Then of course you have to take note that whatever you have the rights to remain silent, or you can cooperate with the police to tell what you know. Right after that, you have to take note of the questions that been asked and answered before you sign, because you have to sign your 112 statement. That is your statement anyway. But why is it that cross 24 hours? It's simply because that it might need longer time to investigate. Probably they will have to search for barang case, the subject matter probably located somewhere further, and when during the arrest it is like at night, that is not enough time to conduct the search at the particular location. Therefore, a few more days is required. So in order to do that, in compliance with the law, the police will then have to bring the OIDS, the suspect person, to court. All right. Why do we go to court? Because we want to obtain a remand order by the magistrate. So in Klang Valley, in practical way, normally the magistrate will then travel to the balai. In KL, it is in Dang Wang Yi and Jinjiang. Yeah, Selangor, of course, PJ Court and so on. Then these are the location where the magistrate will travel to the balai, and there is a special room for it is meant to be a court, right? So the magistrate will then stood up for that case, and all the OIDS, all the suspect will then brought to the court to obtain a remand order. So what happened is there will be plenty of them, and of course you will be normally seen other than the a lawyer of your choice. You have a YBGK lawyer, Yayasan Bantuan Keuangan lawyer is present as well to helping the public on this. So during the remand hearing is whereby the lawyer will have to assess whether is this a necessity to continue detain a suspect for another probably 3 more days, 4 days, or 4 days for the first investigation, or the offense is so serious that you have to one shot given 7 days remand. So that it is for the judge to decide and listen to the IO submission. Now, if you at that point of time, if you have a lawyer represent to you, that lawyer will have to assess and make a judgment whether the police have done enough or competent enough to do the necessity, so that the record percakapan already complete, cap jari already complete, urine test already complete. So what else that you want the suspect to be remain under remand, so that the police will have to tell us or tell the court. Yeah. So if it's convinced that it is an indeed need for more time or to locate someone, have to go somewhere, then probably 2 or 3 days is required. Otherwise, if not all this have not been done for the past 24 hours, so then there is no necessity, probably another day. So that is where during the remand hearing, we can actually raise issues like this before the magistrate. But on the remand hearing itself, there are some essential or more important things to tell the judge. A few things, like if you got arrested, of course, the number one, you can inform the court that you wanted to be represented by a lawyer. That's number one. Of course, you are rights to access to your counsel. It is always there. Because under the CPC, you're allowed to make one call to a person. You can call your lawyers as well. So during that time, you can appoint the YBGK lawyer. You can appoint your own lawyers to speak on your behalf during the remand hearing. Now that is the first thing. Second thing, probably when you got arrested, you have a medical condition, or you got injured. You want to seek medical attention. So during the remand hearing, you can actually ask for the court to allow a medical attention, or send you to hospital. That for that matter, you can actually request during the remand hearing. Other than that, of course, you can actually inform the court what's going on during the interrogations and so on. All this, it is an opportunity that you do not want to miss if you've been arrested, to inform the magistrate this is what I need. But anyhow, I'm not the guilty person. I am facilitate to investigate the offense. The police are charged, probably will be charged on. Okay, so that is the remand hearing process, and eventually the court may or may not granted a remand order. Okay, so what happened if he granted a remand order? That the person will then brought back to the lockup, and the police will continue to investigate. Probably, if the investigation process complete, then you will then be released. Otherwise, if they found that you have suspicion, raise a reasonable, beyond reasonable doubt that you have committed a crime, then you will then all the court paper will pass to the prosecutor to proceed to charge the court. Then there will be another story that Wong Eun will carry on. But then before we go that, at that point of time, a lot of our clients is basically asking, once we got arrested 1 or 2 days, or in fact on the same day, is there any chance that the accused person or the suspect be able to release during the remand? There is always a chance that you can ask for remand. We call it a police bail. A police can post bail to you that you can leave the police station, but that was also subject to the investigation process. This is all at the discretion of the police, which is the superior, the chief of the IO will then decide whether allowed or not allowed. But the judgment call depends on the gravity of the offense. If it is a serious offense, a murder case or drug matter, will never allow a police bail. Otherwise, if it's a less serious offense, it will possible. Now that is a police bail that I'm talking about. Moving on, there is also another type of bail when you charge to court. Then Wong Eun can carry on with that. Yeah, thank you.
So now I will continue with bail. Like Mr. Jason said, police bail may be given after you are arrested and before being charged in court, while court bail is where after being charged but pending the conclusion of the trial, the court may also grant bail and release the person on certain conditions. Whether a person is entitled to release on bail depends on the category of offense charged. We can look at the 5th column of the first schedule of the CPC. If you are charged with a bailable offense, according to Section 387 of the CPC, bail must be granted as of right, and usually no condition is imposed. These are the less serious offenses. And if it is a non-bailable offense, then Section 388 states that it is at the discretion of court to grant bail or not. Conditions may be imposed, such as surrender of passport or report to police every week. These are more serious offenses, such as robbery, rape, or murder. For unbailable offenses, the court has no discretion to grant bail at all. Unbailable offenses are offenses under Section 12 of the Firearms Increased Penalties Act 1971 and Section 41B sub 1 Dangerous Drugs Act 1952. These are also serious offenses. Bail may also be granted pending appeal or retrial. For bail pending appeal against conviction, the court does not lean to granting bail unless there is special reason, while for bail pending appeal against acquittal, the court will lean in favor of granting bail unless the prosecution can show special circumstances to refuse bail. A bail may be granted, can be revoked also. For bailable offenses, the CPC is silent, but case law shows that where a fundamental term is breached, the court has inherent power to revoke the bail, but the accused must be given an opportunity to be heard as to why bail should not be revoked. For non-bailable offenses, according to Section 388 sub 5 CPC, the court may revoke the bail at any stage of the proceedings. Well, now we have talked about bail. Now, what is the flow after the accused is brought before the court? The accused, when he is brought before the court, the charge is read and explained to him. Then he shall be asked to plead. If the accused chose to plead guilty, the prosecution will submit the brief facts, and the accused will be asked as to whether he admits to the facts. The court must make sure the accused understand the nature and consequences of pleading guilty, and the plea must be unequivocal without qualification. If these are satisfied and the accused confirms the brief facts, the court will record the plea of guilt and convict the accused and sentence him accordingly. If the accused does not confirm the brief facts, he will be sent for trial. The guilty plea will be ignored. If the accused does not plead guilty or claims trial, then the pre-trial procedures will be commenced. Pre-trial conference will be held within 30 days from the charge between the prosecution and the accused, and plea bargaining process will also take place in this stage. Then, case management will be held within 60 days from the charge between the prosecution, accused, and the court. If the prosecution and the accused can come into an agreement during the plea bargaining process, they will present the agreement to the court during case management. The case will be disposed of, and the court will sentence on the plea bargain charge and record conviction. If the plea bargain is not successful, the case will proceed to trial. Trial will be commenced within 90 days of the charge. Withdrawal of guilty plea is allowed anytime before sentence pass. After sentence is passed, the court is functus official, which is the court's duty is ended. The accused cannot withdraw the guilty plea anymore. With that, I have done my part on sharing the law on bail and the flow from when the accused is charged. Now, Mr. Statia will give some insights on how things work in practice based on his experience in criminal litigation.
Thank you, Owen. Thank you, Jason, and thank you, Natalie. Thank you, Mr. Jason, for explaining until the remand. So I'll be giving on the actual scenario that will take place in court. Usually after the remand, there'll be once the investigation report is investigation papers are completed, the police will send the IP, which is known as IP, not the short form. It will be sent to the 80 chambers, public prosecutor, which is prosecution, for them to decide whether this particular case to be charged on this particular person to be charged in court or not. Once they have been charged, the process, I'll be explaining the process what will take place once it's charged in court. Once they're charged in court, like Wongan explained, usually it'll be two scenarios. The first scenario, which is whereby the accused, once they've been charged, is known as accused or known as orang yang disyaki. Okay, OYS, orang yang disyaki. Or sorry, orang yang dikena tuduh. They say OKT. Sorry about that. Then once been charged, then the charge will be read to them. Okay, the first scenario when they said, once they said plead guilty, whereby the lawyers will do a mitigation to mitigate the factors to reduce the sentence will be passed against the accused. If in any event, just say about the 12-2 DDA, maybe because of his small offense which usually will be fine. So the lawyers will be doing will be mitigating the factors where the fine to be reduced. While usually in a capital punishment as such as kidnapping, murder, is very rare, or 39B of DDA, Dangerous Drugs Act, it's very rare that people are plead guilty over there. Okay, so the second scenario will be plead not guilty. When they plead not guilty, that's where the lawyers will come in. It depends on the bailable offense, of course, as of right. Unbailable is up to discretion of the court. Non-bailable is discretion of the court, but unbailable usually happens in case like a 5-PAR, 39B, murder and kidnapping, where the bail will not be given because of the seriousness of the offense. In the case of bail, where it can be given, usually the lawyers will mitigate why the bail should be given to the accused and to reduce the bail sum. In usual scenario, if they are Malaysian, they're required to have one surety. Usually it will be immediate family members, could be a parent, spouse, and if they can't, or if cannot, then only the friends will come in. If it's involved for foreigner, when in a offense of bailable or non-bailable, he'll be given the required 2 surety. And the duty of the surety is that to make sure the accused attend the court each time there's a mention or case ongoing. If they didn't turn up on particular day, the surety have to come to court and explain why this accused didn't turn up. And if they are unable to explain or the explanation was unsatisfactory, the court can revoke the bail and issue an arrest warrant. And the police will go after the accused because they have breached the condition of bail. Upon bail is given, so I'm talking about the plead guilty, because once you plead guilty, sentence been passed, the case is closed. So you not plead guilty, out of bail, then there'll be a longer process, like Wongan said. If they first, usually as practitioners, as criminal practitioners, we will send a letter of representation to the AG chambers. Either there will be they can be a 2 scenario. Either ask them to withdraw the entire charge or to reduce the charge. If they withdraw the entire charge, there won't be any charge against there's no any guilty plea against the accused, and he will be acquitted. If reduced, they agree, then we'll be doing then the charge will be read again to him for the reduced amended charge, and you'll agree plead guilty. Then once you plead guilty, then the lawyers will do the mitigation, how they used to do at the early stage, because they already plead guilty for the reduced charge. Okay, that's the first one scenario. If it's not, just say representation has been rejected in scenario to reduce to withdraw the entire charge, and then the trial will take place. That's where the plea bargaining will comes in and trial. Once the trial take place, the prosecution will start their case first, because they need to prove their case. Once they have proved their case, then there's a prima facie been established. Then the defense have to give testimony in court. Once the testimony is given, then the court might decide. The early stage and prosecution stage, the court might decide whether to enter defense or not. Either there will be 2 scenarios, either enter defense or you'll be acquitted. If enter defense, then the accused and all his other witnesses need to give testimony. Then the court will decide whether conviction will be recorded against him or he'll be acquitted. In any event, if he's acquitted, then if he's acquitted, then there's a possibility that the AG chambers or the public prosecutor can appeal against a decision given by the judge. Could be magistrate court judge, magistrate or sessions court judge, to the High Court. And it goes to the kidnapping cases, 39B of DDA and murder, where the case will be dealt, capital punishment, which involve capital punishment, that will be dealt in High Court, and they can appeal to the Court of Appeal. If they have been convicted, a good example I can give you will be Datuk Sri Najib's case, in SRC's case, where the High Court have convicted him, but they filed a stay pending appeal, bail pending appeal, and the bail some might be increased or with other extra condition, or they might maintain the same bail. So basically, the accused is convicted, but is still be out on bail with increased sum or with other extra condition will be imposed pending appeal. There still will be, because the case is still in pending appeal, so they're still out on bail. That can go in like that example. But in certain scenarios, they might revoke. It's very hardly in the criminal cases where they revoke bail pending appeal. It depends on the scenario. And this is a process that will take place, and usually the process will be a bit lengthy, not lengthy, but it depends. So what my advice is that many people have said, although it's a small but they must take account once they've been convicted, any criminal offense, doesn't matter, could be a very small petty theft or anything. Once they've been been convicted, there'll be a criminal record, and this can lead to their livelihood can be affected. So that, and a lot of people don't see the seriousness that require a lawyer to represent them when they've been charged in court. We understand that sometimes some people can't afford to have appoint a lawyer. That's why the YBGK is there to help them. So we encourage people, those who've been charged, for any offense, don't take it very lightly. Please consult a lawyer if you can afford. If no, means go to YBGK centers. There's in KL, you can have a look, and they'll be assisting you. So that's all from my side. Back to you, Ong.
All right. Thank you, Mr. Satya. And also thank you, Mr. Jason and Wong Eun, for sharing your experiences and also the law with us. So through today's talk, we actually just hope that everyone, you can alert on your rights, and also you have to know what you have to do and also you can do when you are arrested. Okay, so once again, thank you very much to all our speakers today, and also not to forget all the audience who actually joined us today. So for next week, we will be talking about police search, which means can police search you when, for example, you're walking in a public and the police suddenly want to search you without warrant? Or can the police just enter into your premise to check your premise, which is your house? So if you want to know your rights about this police search, stay tuned and join us next Sunday at 3 p.m. Thank you, everyone.